Здравствуйте, уважаемые друзья! Сейчас утро, за бортом 6 градусов. И я, как обычно, по утрам слушаю американское радио Вермонта, Public Radio. И сейчас идет доклад, зачитывается по вмешательству русских в американскую кампанию прошлого избирательного цикла. Послушайте, реально очень интересно.
The special counsel's report did not find that any person associated with the Trump campaign illegally participated in the dissemination of the materials. Finally, the special counsel investigated a number of links or contacts between the Trump campaign officials and individuals connected with the Russian government during the 2016 presidential campaign. After reviewing these contacts, the special counsel did not find any conspiracy to violate U.S. law involving Russian-linked persons and any persons associated with the Trump campaign. So that's the bottom line. After nearly 2 years of investigation, thousands of subpoenas, hundreds of warrants, and witness interviews, the special counsel confirmed that the Russian government sponsored efforts to illegally interfere with the 2016 presidential election, but did not find that the Trump campaign or other Americans colluded in those efforts. After finding no underlying collusion with Russia, the special counsel's report goes on to consider whether certain actions of the president could amount to obstruction of the special counsel's investigation. As I addressed in my March 24th letter, the special counsel did not make a traditional prosecutorial judgment regarding this allegation. Instead, the report recounts 10 episodes involving the president and discusses potential legal theories for connecting those activities to the elements of an obstruction offense. After carefully reviewing the facts and legal theories outlined in the report, and in consultation with the Office of Legal Counsel and other department lawyers, the Deputy Attorney General and I concluded that the evidence developed by the special counsel is not sufficient to establish that the president committed an obstruction of justice offense. Although the Deputy Attorney General and I disagreed with some of the special counsel's legal theories and felt that some of the episodes examined did not amount to obstruction as a matter of law, we did not rely solely on that in making our decision. Instead, we accepted the special counsel's legal framework for purposes of our analysis and evaluated the evidence as presented by the special counsel in reaching our conclusions. In assessing the president's actions discussed in the report, it is important to bear in mind the context. President Trump faced an unprecedented situation. As he entered into office and sought to perform his responsibilities as president, federal agents and prosecutors were scrutinizing his conduct before and after taking office and the conduct of some of his associates. At the same time, there was relentless speculation in the news media about the president's personal culpability. Yet, as he said from the beginning, there was in fact no collusion. And as the special counsel's report acknowledges, there is substantial evidence to show that the president was frustrated and angered by his sincere belief that the investigation was undermining his presidency, propelled by his political opponents, and fueled by illegal leaks. Nonetheless, the White House fully cooperated with the special counsel's investigation, providing unfettered access to campaign and White House documents, directing senior aides to testify freely, and asserting no privilege claims. And at the same time, the president took no act that in fact deprived the special counsel of the documents and witnesses necessary to complete his investigation. Apart from whether the acts were obstructive, this evidence of non-corrupt motives weighs heavily against any allegation that the president had a corrupt intent to obstruct the investigation. Now, before I take questions, I want to address a few aspects of the process for producing the public report that I am releasing today. As I said several times, the report contains limited redactions related to 4 categories of information. To ensure as much transparency as possible, those redactions have been clearly labeled so that the readers can tell which redactions correspond to which categories. Now, as to recall, those categories are 6E material, grand jury material, information that the IC believes would disclose sources and methods, information that would impair the investigation and prosecution of other cases that are underway, and finally, information that implicates the privacy and reputational interests of peripheral third parties. As you will see, most of the redactions were compelled by the need to prevent harm to ongoing matters and to comply with court orders prohibiting the public disclosure of information bearing on ongoing investigations and criminal cases, such as the IRA case and the Roger Stone case. These redactions were applied by Department of Justice attorneys working closely together with attorneys from the special counsel's office, as well as the intelligence community, and prosecutors are handling the ongoing cases. The redactions are their work product. No redactions done by anybody outside this group. There were no redactions done by anybody outside this group. No one outside this group proposed any redactions, and no one outside the department has seen the unredacted report, with the exception of certain sections that were made available to IC, the intelligence community, for their advice on protecting intelligence sources and methods. Consistent with longstanding executive branch practice, the decision whether to assert executive privilege over any portion of the report rested with the President of the United States. Because the White House had voluntarily cooperated with the special counsel, significant portions of the report contained material over which the President could have asserted privilege, and he would have been well within his rights to do so. Following my March 29th letter, the Office of the White House Counsel requested the opportunity to review the redacted version of the report in order to advise the President on the potential invocation of privilege, which is consistent with longstanding practice. Following that review, the President confirmed that in the interest of transparency and full disclosure to the American people, he would not assert privilege over the special counsel's report. Accordingly, the public report I am releasing today contains redactions only for the 4 categories that I previously outlined, and no material has been redacted based on executive privilege. In addition, earlier this week, the President's personal counsel requested and was given the opportunity to read a final version of the redacted report before it was publicly released. That request was consistent with the practice followed under the Ethics in Government Act, which permitted individuals named in a report prepared by an independent counsel the opportunity to read the report before publication. The President's personal lawyers were not permitted to make and did not request any redactions. In addition to making the redacted report public, we are also working with Congress to accommodate their legitimate oversight interests with respect to the special counsel's investigation. We have been consulting with Chairman Graham and Chairman Nadler through this process, and we will continue to do so. Given the limited nature of the redactions, I believe that the publicly released report will allow every American to understand the results of the special counsel's investigation. Nevertheless, in an effort to accommodate congressional requests, we will make available, subject to appropriate safeguards, to a bipartisan group of leaders from several congressional committees, a version of the report with all redactions removed, except those relating to grand jury information.
Короче говоря, значит, это просто уже заключение, я так понимаю. Короче говоря, отчет показал, что никакого сговора между Трампом и президентом России, Российской Федерации, не было. Отчет показал, что были попытки вбросов оплачиваемых, да, и попытки хакнуть, значит, сервера. То есть такого рода вещи, как бы. Но эти действия были никаким образом не скоординированы с офисом Трампа. Значит, никакого вмешательства в расследование, что тоже очень важно, кстати, не было. Трамп был недоволен тем, что с самого начала его президентство, его постоянно травили тем, что он сговаривался с русскими. Все его действия, они носили скорее эмоциональный характер, нежели характер, связанный с... Характер его действий был связан с намеренным вмешательством в ход следствия. И последнее, президент не стал пользоваться своей возможностью не допускать обнародования этого самого доклада. Он сказал, что наоборот, пожалуйста, публикуйте, я хочу, чтобы мое имя было чистым, за исключением информации, связанной с секретной службой, да, с тем, чтобы не были рассекречены агентурные данные для того, чтобы не пострадала безопасность страны. В общем, вот такая вольная констатация того, что сейчас говорилось в этом отчете. Я с ним откланиваюсь. Всем хорошего дня и счастливо.